I want to introduce myself. Joanne Gauthier. I've been a member of the federal court since 2002, sitting for many years with what was then known as the Federal Court of Canada Trial Division before being appointed to the Federal Court of Appeal in 2011. Je suis une des 5 juges de la Cour d'appel fédérale qui représentent le Québec et la tradition civiliste, telle que requis par la loi sur les cours fédérales. Je salue donc spécialement tous les gens qui se sont joints à nous du Québec. Mes collègues québécois sont tous fiers de vous représenter et je peux vous assurer qu'un cœur de Beauceronne, parce que ma famille maternelle est de Saint-Gédéon, ça n'oublie jamais ces valeurs sociales, les valeurs sociales dans lesquelles nous avons grandi et continuons d'évoluer, quel que soit notre lieu de résidence ou de travail temporaire. I have the pleasure and the honor of being the face and the voice greeting you on behalf of the Federal Court of Appeal and the Federal Court today. We would all have loved to celebrate this anniversary in person with you. But because of the special circumstances related to COVID, we cannot get together in person. Vous serez sûrement d'accord avec moi qu'une fête par Zoom, ce n'est pas aussi chaleureux, mais c'est tout de même mieux que pas de célébration ou de fête du tout. A 58th birthday, that's half a century, whether one is an individual or institutions like the federal courts, is an important milestone. La date de notre 50e anniversaire était en juin 2021. Nous avons alors célébré en famille, c'est-à-dire avec tous ceux et celles qui font partie de l'organisation, par Zoom, naturellement. Le plan initial du comité organisateur était de tenir, en juin 2021, plusieurs journées d'activité. Plutôt que de tout annuler, le comité organisateur a décidé d'échelonner certains événements au cours de l'année, espérant un retour à ce qu'on appelle encore la normale et d'avoir une grande rencontre en personne en juin 2022. As you know, when you have a birthday present, you can't wait, at least I can't. You have to rip open the wrappings and enjoy the present. Our present on this birthday celebration is this wonderful book about the Federal Court of Appeal and the Federal Court. Today is the official launching of the fabulous commemorative book dans les 2 langues officielles. Je vous les montre et je remercie les éditeurs, les presses de l'Université de Montréal et Irving Law. Comme vous voyez, ils ont fait un très beau travail. Ils sont différents, bleu et or. Mais selon moi, ce sont de magnifiques ouvrages. La célébration et je dois vous dire, parce que vous allez peut-être vous demander pourquoi 2 livres ou 2 versions, c'est parce que c'est essentiel pour nous étant vraiment truly bilingual courts. This book describes some of the challenges and the achievements of our court in the last 50 years. What a great job by the 4 authors who you will meet today. For them, their research assistant and the other superb contributors, which you will see in one of the slides of the PowerPoint, it was years of research and dedication. One of our challenges is to ensure that the Canadian public has a better understanding of the essential role of our courts in the judicial landscape and what makes us different. The 2 versions of the book accomplish this objective in a wonderful way. Today, we have 2 goals. First, to celebrate our anniversary in a more public way and remember our history and those who contributed to these great institutions. This anniversary is thus a tribute to the many judges who have tirelessly traveled across our great country for the last 50 years to meet Canadian litigants' needs and to develop a uniform and consistent jurisprudence. A jurisprudence that ensures that a litigant residing in BC is treated the exact same way as a resident in Newfoundland in all matters within the federal jurisdiction that have been assigned to our courts. It is through 50 years of hard work by our predecessor and ourselves that the federal courts have advanced the rule of law in Canada. And we all know that the rule of law is the cornerstone of our democracy. The second goal is to present this book. It is a must-read for anyone interested in our judicial system. 50 ans d'histoire, ce n'est pas une œuvre de doctrine destinée seulement aux juristes. C'est un ouvrage qui décrit notre histoire, notre culture, nos défis et l'apport important de nos cours au développement du droit canadien. Je le répète, il devrait être lu par quiconque s'intéresse au système de justice au Canada. Et ce système de justice est un de nos plus importants fleurons. Il demeure la pierre angulaire de la démocratie canadienne. Comme Canadiens, nous devons en être fiers, et pour en être fiers, il faut le connaître. The program today is simple. There will be about an hour of presentations. Unfortunately, this means that the authors will only have a few minutes each. That can hardly do justice to what they so carefully wrote in this very substantial work. I would describe thus the day almost as a teaser. To really appreciate just how rich this book is, you must get this book. I guarantee that you will be happy you did so. A brief introduction by one of our past Chief Justices, the Honorable Frank Kabuti, will be followed by a few remarks by our current two Chief Justices and a general presentation by the four main authors. This should leave about 25 minutes for questions. We want to hear from you and to answer your queries, so please send some. The Honorable Frank Kabuti, who wrote the formal introduction to the book, will now say a few words. He truly is a giant in the Canadian landscape. His remarkable career has given him a unique and multifaceted perspective on the federal courts. He practiced law and then was a professor and the dean of a law faculty, a deputy minister of justice, a chief justice of the Federal Court of Canada, and a member of the Supreme Court from 1991 to 2004. He still serves Canadians in various ways, and I encourage you to read his brief biography included in your material. And I encourage you to do the same when I present the four authors, because I don't have time to go through all their achievements, and there are many. So, Mr. Kabuti, the floor is yours.
Merci, Madame la juge Gauthier. Je suis très heureux d'être avec vous aujourd'hui pour participer au lancement du livre célébrant le 50e anniversaire de la Cour fédérale du Canada. J'avais pris part au 20e anniversaire de la Cour en 1991 et je me demande comment 30 ans ont pu passer aussi vite. Je dois dire que quand j'ai toujours avec un accent de la langue de Dante qui domine. As I mentioned in my preface to the book, an anniversary is an event that triggers thoughts about the past, the present, and the future. A short description of this book being launched is just that, because the book ably and lucidly covers topics dealing with the three temporal dimensions. I believe it is fair to say that although the Supreme Court of Canada and the predecessors to the federal court, the Exchequer Court of Canada, were founded in 1875, both faced controversy and criticisms that were exacerbated by the fact that the 6 judges of the Supreme Court were also trial judges of the Exchequer Court. Many felt judicial ties to England should be maintained, and so civil appeals, as we know, to the Privy Council from the Supreme Court continued until 1949, when Canada finally becomes of age, juridically speaking. And with respect to the Exchequer Court, many members of the provincial bars and bench objected to a federal Ottawa tribunal being involved in claims against the federal government. Finally, on the point of criticism and controversy, appointments to the benches of both courts reflected the extensive patronage practice of the time, such that many judicial appointments were of questionable quality. However, this book illustrates that all of those early concerns have disappeared. And here I wish, as Madame Lejeune has mentioned, I wish to salute the men and women who have served on the federal court, both in the trial and appeal courts. They deserve so much credit and recognition for their outstanding contributions. And I include in that compliment the many members of the loyal staff of those courts. Simply put, the federal court decisions are of fundamental importance to the administration of justice in our country. In such diverse fields as administrative law and judicial review, Aboriginal law, intellectual property, national security and intelligence, immigration and refugee law, admiralty, and taxation, the federal court's role is pivotal. Obviously, when discussing the future of any institution, one cannot be very precise. However, based on the judicial culture and record of the federal court for the last 50 years that have shown commitment, resilience, excellence, and professionalism, we can be encouraged, confident, and grateful for what has been accomplished. Those accomplishments are a harbingers of good things to come. On a personal note, I wish to acknowledge my colleagues with whom I served while on the Federal Court of Appeal and those on the Federal Court Trial Division. I learned so much from them about the role of a judge, and at the same time, greatly enjoyed their collegiality and friendship. Je termine mes remarques en remerciant et en félicitant les auteurs et les éditeurs pour les excellents articles qui ont été écrits. Ensemble, ils ont rendu un bel hommage de la part des milieux de la recherche et des affaires aux contributions de la Cour fédérale depuis les 50 dernières années. The courts we celebrate today could not have a better birthday present that can be shared not only with those interested in the work of the courts, but also with the wider Canadian public. Thank you.
Thank you very much, Mr. Kabuti. C'est maintenant au tour des deux juges en chef de vous parler. First, the Chief Justice of the Federal Court of Appeal, Marc Noel, who has been a member before being, has been a member of the federal court since 1992. So he has lived through 29 years of the 50 years that we're now celebrating. He was appointed in 1992 and became Chief Justice of the Federal Court of Appeal in 2014. His remarks will be followed directly by le juge en chef Paul Crampton, qui a été nommé à la Cour fédérale en 2009 et est devenu juge en chef en poste à ce titre à partir de 2011. Alors, les juges en chef, la parole est à vous.
Merci. Well, first, let me thank you, Frank, for this informative and heartfelt introduction. No one can talk about the federal courts with the same passion and authority as you. You've been you've seen the federal courts from every conceivable angle. This is a great start for this historic book launch. Merci, Madame la juge Gauthier, pour l'occasion qui m'est donnée de prendre la parole en marge de ce lancement commémorant le 50e anniversaire de la création de la Cour fédérale du Canada. Those behind the creation of this new court had a vision. They foresaw a court that would oversee the fair and just uniform application of federal laws from coast to coast, and that would grow to become an important part of the lives of Canadians. The book being launched today shows that the federal court's 50-year story unfolded as its founding members hoped it would. From the distant Exchequer Court that was being replaced, the federal courts became a significant part of the judicial landscape in Canada. Comme je le rappelais lors de la journée marquant notre 50e anniversaire, ce à quoi nous assistions ce matin du 1er juin 1971 était la création d'une Cour nationale, bilingue, bijuridique et accessible à tous. Il s'agissait d'un virage assumé vers la modernité, l'ouverture et l'inclusion. Pour la première fois dans le monde juridique, toute cour et toute juridiction confondues, le mariage de deux langues, de deux cultures et de deux grands systèmes juridiques devenait la pierre d'assise d'une cour de droit. Comme le raconte si bien le livre que nous lançons aujourd'hui, l'esprit d'ouverture et de respect mutuel qui se dégage de ce mariage a fidèlement guidé notre destin et nous a permis de mieux répondre aux aspirations de ceux et celles que nous sommes appelés à servir. The task of writing a 50-year anniversary book on the federal courts was by no means an easy one. The federal courts have many distinguishing features, ranging from their bilingual and bijural status to their numerous areas of specialized jurisdictions, all different, but whose common trait lies in their ever-increasing importance as the years unfold. As can be seen from the book, more than a few pages, indeed well over 600, were required to present a fair picture of the story to date. I take this occasion to thank the judges on the organizing committee and the staff members who worked so hard to make this publication possible. Particular thanks to the drivers of the project, Judges Simon Noel and Richard Boivin. Special thanks also to those who edited the book and authored its key chapters, Professors Ian Green, Martine Valois, Peter McCormick, and Craig Forsese. They were given extensive academic freedom and used it fully. The result is a true and fair depiction of our history that will forever be inscribed in our collective memory. Ce livre raconte notre passé, mais il laisse aussi entrevoir l'avenir. Regardant vers l'avant, le modèle inclusif qui nous a si bien servi par le passé pourrait certes être utilisé pour répondre à d'autres aspirations, au-delà de celles qui étaient envisagées en 1971. L'un des chapitres du livre décrit l'importante contribution des cours fédérales au développement de la jurisprudence en matière de droit autochtone. Au point où nous en sommes, nous devons utiliser notre expérience d'ouverture et d'inclusion afin de voir comment nous pouvons intégrer dans nos pratiques les modes et traditions que partagent les peuples autochtones. L'initiative récente prise par la Cour fédérale de publier les décisions impliquant les Premières Nations dans la langue qui leur est propre et la réaction enthousiaste qu'elle a suscitée à même ces communautés démontrent comment des gestes d'ouverture, même les plus simples, peuvent faire avancer les choses. La tâche devant nous est énorme. Même après 50 ans, les cours fédérales sont des œuvres inachevées. I close by expressing my deep gratitude to those about whom this book is all about. I'm speaking of the judges, patenataries, registry officers, and staff members who have built our history to date. May those who are called upon to write the next chapter be blessed with the same courage, determination, and fortitude as those who led us through the first 50 years. Merci et bonne lecture. I now invite my colleague, Chief Justice Crampton, to speak.
Merci beaucoup, Juge en chef Noel. Moi aussi, j'aimerais commencer par remercier sincèrement, tout comme l'a fait le juge en chef Noel, les membres du comité organisateur et ceux qui les ont appuyés pendant le long parcours qui a mené au lancement de cet ouvrage. Soyez certains que nous sommes conscients du travail acharné qu'ont nécessité la conceptualisation du livre, la concrétisation du plan et l'enrichissement de l'ouvrage au fil des mois. J'aimerais également en profiter pour remercier les auteurs des divers chapitres, en particulier ceux qui ont rédigé plusieurs chapitres ou y ont contribué et ont de surcroît assumé des responsabilités éditoriales. Je parle ici des professeurs Green, Valois, McCormick et Forces. La Cour fédérale vous en est infiniment reconnaissante. Je tiens également à souligner la contribution toute spéciale du juge Simon Noel, qui a présidé le comité organisateur et qui, depuis le tout début, était l'une des forces motrices de ce livre, avec bien sûr le juge Boivin, qui je remercie aussi. And as with Chief Justice Noel, I would like to thank retired Chief Justice and retired Justice Kabuti for his kind remarks and for being available to those of us on the court when we have sought to reach out to him. On June 1st, 2021, our formal 50th anniversary, the members of the federal courts held a special sitting to commemorate the event. We also took the opportunity to share some very precious video clips and reflections. I encourage those of you who have not yet seen the video recording of the event to take the time to do so. It is available on YouTube. At that time, I noted that the establishment of the Federal Court of Canada in 1971 was part of a broader goal of establishing a just society. Chief Justice Noel and I also briefly discussed the court's intellectual underpinnings. This book that's being launched today skillfully charts the ensuing journey of the court, the two divisions of which split into what are now known as the Federal Court of Appeal and the Federal Court, effective July 2nd, 2003. The book provides rich detail and insights into how the courts breathed life into their jurisdiction and assumed their unique roles in Canada's justice system. Special chapters are dedicated to the various core areas of that jurisdiction that retired Justice Kabuti just identified. These chapters provide a very convenient and accessible resource on the contributions of the two federal courts in these areas. They also demonstrate how the court's intellectual foundations remain as relevant and strong today as they were half a century ago. Beyond those chapters, the book provides a further treasure trove of information and insights. Among other things, it provides invaluable historic information that builds upon Ian Bushnell's seminal work that covered the first 20 years of the Federal Court of Canada's existence. As a special treat, Chapter 5 offers us a synthesis, a wonderful synthesis of almost 80 interviews of current and retired judges. And for those who are interested in what the future may hold, I commend the final two chapters, which were written by Chief Justice Noel and yours truly, respectively. As you might well expect, we address the technological transformation that was accelerated over the last 18 months due to the COVID-19 pandemic. Fortunately, the two courts were well positioned for that transformation. In the case of the federal court, this was to no small degree because of the investment we had previously made in strategic planning. In addition to summarizing the highlights of our current 5-year plan and the preceding 5-year plan that was adopted in 2014, Chapter 17 of the book provides an overview of the implementation of those plans. It also discusses, for the first time publicly, our 2014 internal plan. Suffice it to say that as the federal court transitions back towards much more significant use of in-person hearings, it will be doing so in a manner that leverages the technological progress that has been achieved and will remain ongoing. There will be no going back to the way things were before, at least not on a generalized basis. There will be a new normal, which reflects the court's ongoing shift away from being primarily a paper-based organization to being a more digital and more accessible court. À chaque étape du parcours, la Cour restera fidèle à sa mission de rendre la justice et d'aider les parties à régler leurs différends juridiques partout au Canada, dans l'une ou l'autre des langues officielles, d'une manière qui respecte la primauté du droit et qui est indépendante, impartielle, équitable, accessible, efficiente et adaptée à la situation. J'espère que vous aimerez ce beau livre. Merci.
So thank you very much for your remark, Chief Justice Noel and Crampton. We're now into phase 2 or part 2 of the session, which is the presentation by the authors of the book. The order of presentation, we start with Professor Ian Green, who has been teaching, who taught for more than 40 years, since 1985, or this is almost 50 years, at the University of York, followed by Martine Valois de l'Université de Montréal, ensuite par le professeur Greg Forsisi de l'Université d'Ottawa, et finalement par le professeur McCormick, qui a enseigné à l'Université de Lethbridge pour 40 ans. Alors, comme vous voyez, ce sont tous des gens avec beaucoup d'expérience. Et encore une fois, je vous recommande de lire leurs notes biographiques qui sont dans votre matériel. Alors, Professor, the floor is yours.
Well, thank you very much, Justice Gauthier, and thank you, Justice Kabuti, Chief Justice Noel, Chief Justice Crampton, for giving us some background to this project. And I just want to say how much the 4 co-authors appreciate being invited to participate in this wonderful project. And we appreciate the help of all of you and also the court's administration service, which was invaluable with all the work that we did. So could I have the next slide, please? The 4 of us put together this slide presentation, and we decided it should be both in French and English, which is like the court itself. And I just love that about the nature of Canada, where you can switch back and forth between the 2 languages, not necessarily having to translate. So this project began in 2017 when the steering committee, which has already been mentioned, decided there ought to be a book to celebrate the 50th anniversary of these 2 courts. And one member of the committee was Justice James O'Reilly, whom I got to know. We were both active fellows of McLaughlin College at York University. He came to see me to talk about the book project. And I said, well, it sounds absolutely fascinating. I think there should be interviews with all the judges on the 2 courts and retired judges. My colleague Peter McCormick and I have had a lot of experience doing that sort of thing in previous projects, but there need to be other people involved for a project of this size. I thought of Craig Forsisi at the University of Ottawa, whom I got to know. Both of us did some work through the Oliphant Commission a decade ago. And the steering committee suggested Martine Valois, who has the background in the bilingual and bijural aspects of the court, which is so much needed. So fortunately, all of us agreed to get involved. And could I have the next slide, please? Peter McCormick and I have developed ways of studying courts and judges that I think are pretty unique. And it was a chance for us to do these kinds of things once again, but also pass on these approaches to our research assistants who will be able to take over in the future. So could I have the next slide, please? So we had to come up with a plan for the book, which you see the first half of the book mentioned here. We're so glad that Justice Kabuti was able to get involved, as well as Justice Descaries for the epilogue. You'll see that the four main authors wrote several of the chapters each, but eventually we had to have some help from others because it was such a massive project. We wanted to have a chapter not only on the results of the research that we did with interviews. The four of us interviewed all of the judges on the two courts and a number of retired judges. All these interviews were recorded audially, many by video as well. They were all transcribed. They were analyzed with computer analysis. It was a huge, huge project. So we were involved in these kinds of things, but we had a number of people who helped us with some of the more specialized chapters, like Paul Daly. Next slide, please. Jeremy De Beer, Dwight Newman, Jocelyn Stacey, David Colford, Carolyn Carter, Stephen Rita Proctor, Anik Provache. So we're grateful for these people for their contributions. And could I please have the next slide? So we had to develop a questionnaire to put to all the judges. We had help from the steering committee, and also all of us used our own past experience in studying courts to develop the questionnaire. We had to get permission from the research ethics boards at our four universities to go ahead with this project. We needed to have a budget, not for ourselves, but to pay for our research assistants. And fortunately, the Courts Administration Service was able to help us with that. So we also asked the judges to fill out background questionnaires that gave us additional information about the education and backgrounds of the judges and so on. And all this was combined with the data from the interviews. And could I have the next slide, please? So at the beginning of the book, we go over the history of the court, which is kind of a summary of to begin with, what's already in the Bushnell book, which has been mentioned. But of course, everything started out with the Exchequer Court in the late 1800s, and then went on to the Chief Justice of the head of the Exchequer Court in the late 60s was Wilbur Jacket, who had a vision of a much more enhanced court that would become one of Canada's nation-building institutions. John Turner, the Justice Minister, shared that vision with Wilbur Jacket, and planning for the new federal court began in 1968. There was a great deal of consultation right across the country with regard to establishing this new court or enhancing the Exchequer Court. And there was some opposition, especially in BC, but in the end, the motion to approve the legislation was approved unanimously in the House of Commons. But BC opposition, can I have the next slide, please? Opposition continued, especially in British Columbia. And at one point, there was a motion taken to the Canadian Bar Association, was this in 1991, to abolish the federal court. It failed by only one vote. Anyway, the court has survived and it has thrived since that time. Could I have the next slide, please? The federal court from my perspective, is the most interesting court in the country. For one reason, it's the most diverse court. The judges in both courts were educated, their undergraduate degrees are from across Canada, and their law degrees represent practically all the law schools across the country. There's no other court in the country that is as diverse in that aspect as the federal court and the Federal Court of Appeal. I think you see the benefit of that diversity in the decisions that are written by the judges of both courts. Could I have the next slide, please? Of course, the jurisprudence of the Supreme Court has had an impact on not only the jurisdiction, but the nature of the federal court itself. And one of the questions we posed to all of the judges we interviewed, current and retired, is what are the Supreme Court decisions that have had the greatest impact on the federal court and the Federal Court of Appeal? And at the bottom of the slide, you can see the decisions that were mentioned most of the time by the judges that we interviewed. And in the book, we look at more specifically at these decisions and the specific impact that they had on the court. Next slide, please. Some of the highlights from the interviews that we did. The next slide, please. Great. So what are the primary successes of the court? Well, as you can tell, since nobody was reluctant to talk to us, the members of the court were very happy to be interviewed. They love their court. They're proud of their court. And they're proud of the accomplishments over the last 50 years. The court has thrived, not only survived that challenge in 1991, but it has thrived since that time. And the court now has a good reputation for the kinds of decisions that it makes. Next slide, please. What are the challenges of the two courts over the next 50 years? Well, as you can well imagine, making better use of technology is one of the major challenges. I think the federal court already does make better use of technology than most other courts in Canada, but most members of the court said that needs to be improved. The court needs to be more diverse, not only in terms of the law schools that it represents, but it needs to be diverse in terms of representing the nature of Canada in terms of where people in Canada come from and their ethnic and racial backgrounds. The overlap with the jurisdictions of other court needs to be addressed and so on. And the nature of the court is an itinerant court where the judges travel across the country, which is one thing that makes it unique. It needs to be addressed a bit because it also, for some judges, it makes it very difficult to think about applying for a position in the federal court. So there are a number of issues that need to be addressed. Now I'd like to ask my colleague, Martine Valois, to speak about some of the research that she did for this book. Next slide, please.
Bonjour, merci au professeur Green. Comme lui, je voudrais remercier le comité du 50e anniversaire de nous avoir permis aux 4 auteurs principaux de participer au lancement des 2 ouvrages. Pour ma part, j'ai rédigé 3 des chapitres de l'ouvrage. Un chapitre sur le bijuridisme et le bilinguisme devant les cours fédérales, un chapitre avec Henri Barbeau, maître Henri Barbeau, que je veux remercier ici, sur le droit de l'immigration et des réfugiés devant les cours fédérales, et également un chapitre sur l'indépendance administrative des cours fédérales. Donc, ce chapitre, j'ai pris la décision et suggéré au comité de le rédiger après avoir fait les entrevues avec les juges des cours fédérales et parce que je pensais que ce sujet-là devait être traité dans ce livre. Donc, je vais vous parler brièvement des faits saillants des 3 chapitres que j'ai écrits. Tout d'abord, le chapitre 6 sur le bijuridisme et le bilinguisme devant les cours fédérales. D'ailleurs, tout d'abord, on peut dire que les cours fédérales sont un forum naturel pour le bijuridisme au Canada, puisque des juristes formés dans les deux grandes traditions, les deux systèmes juridiques canadiens plaident devant ces cours. L'article 5.4 de la loi sur les cours fédérales prévoit qu'au moins 5 juges de la Cour d'appel fédérale et 10 juges de la Cour fédérale doivent venir du Québec. Ces juges sont formés en droit civil et ils ne perdent pas leur connaissance dans ce domaine du droit une fois nommés. Dès le début des années 90, le ministère de la Justice amorçait un projet d'harmonisation des lois fédérales qui a donné lieu à l'adoption en 2001 de 2 articles dans la loi d'interprétation canadienne qui exigeait, en fait, qui proposait qu'on devait avoir recours au droit civil, soit le droit civil québécois ou la common law dans l'interprétation des concepts de droit privé qui se trouvent dans les lois fédérales, dont la loi sur l'impôt sur le revenu, comme par exemple la loi sur l'impôt sur le revenu. Concernant le bilinguisme des cours fédérales, comme vous le savez, les sources de cette obligation de bilinguisme sont nombreuses. Tout d'abord, l'article 133 de la loi constitutionnelle de 1867, ainsi que les articles 14 et suivants de la loi sur les langues officielles et également l'article 19 de la Charte canadienne des droits et libertés. Ces droits linguistiques sont des droits fondamentaux. Ils obligent les cours à permettre aux participants et aux témoins de choisir la langue officielle de leur choix et imposent aussi l'obligation de comprendre la langue officielle choisie par la partie ou le témoin. Dans l'affaire Masrani de la Cour rendue par la Cour d'appel fédérale et qui a été confirmée par la Cour suprême du Canada intégralement, on a décidé qu'il existait un droit exclusif, c'est-à-dire seule la personne pouvait faire ce choix pour toute personne, et donc y compris un témoin, de choisir la langue dans laquelle il s'exprimera devant les cours fédérales. Malgré l'article 20 qui pose le principe de la publication des jugements des cours fédérales dans les 2 langues, cet objectif ne peut pas être respecté dans tous les cas. L'absence de traduction de tous les jugements des cours fédérales dans un délai court fait en sorte qu'une partie des justiciables n'a pas accès au jugement dans leur langue officielle. Prochaine diapositive, s'il vous plaît. Maintenant, le chapitre 7 concerne l'indépendance administrative des cours fédérales. Donc, comme vous le savez, la Cour suprême du Canada a, dans la Revalente tout d'abord et dans plusieurs autres jugements, a énoncé 3 conditions essentielles de l'indépendance judiciaire, soit la nomination à titre inamovible des juges, la sécurité financière des juges et également l'indépendance administrative ou institutionnelle des cours de justice. Ces 3 conditions sont essentielles pour assurer la confiance du public dans l'administration de la justice. L'indépendance administrative comme condition essentielle touche tout ce qui comprend, tout ce qui touche directement les fonctions judiciaires, soit les rôles, l'assignation des causes, la gestion des délais, la disponibilité des salles, du personnel du greffe, la rédaction et traduction des jugements, l'accès aux tribunaux par des moyens électroniques pour le dépôt des procédures et des documents, etc. Le manque de financement et de ressources sont les causes principales des dysfonctionnements dans le processus judiciaire, les délais, la disponibilité des juges en nombre suffisant, les services d'interprètes, mais l'organe exécutif n'est pas cet organe à qui l'on demande de régler ces problèmes. Ce sont les juges qui sont en première ligne, qui font face aux critiques et qui doivent régler ces problèmes et donner une réponse rapide à ces problèmes. Le modèle exécutif de gestion des tribunaux, qui est le modèle généralement appliqué au Canada, est inadéquat. Il ne permet pas l'indépendance financière des tribunaux. Il impose un contrôle limité des juges en chef sur les affaires de la Cour. L'administration des tribunaux est confiée à un administrateur qui relève du pouvoir exécutif. Ce modèle exige beaucoup d'interactions entre l'exécutif et la magistrature, ce qui augmente les délais, les difficultés et provoque l'érosion de la confiance mutuelle qui doit exister entre les deux. Également, ces interactions vont à l'encontre du principe de dépolitisation des relations entre le pouvoir exécutif et judiciaire qui est exigé par la Cour suprême du Canada. Selon les auteurs qui sont cités dans ce chapitre, le service d'administration des tribunaux judiciaires est une version du modèle exécutif, puisque l'administrateur en chef ne relève pas des juges en chef. L'obligation de consultation des juges en chef s'impose seulement sur certaines matières par l'article 5. Le contrôle des juges en chef des cours fédérales sur la gestion du greffe et des services est limité. Et la séparation des fonctions prévues dans la loi entre l'administrateur en chef et le juge en chef est une division théorique entre les pouvoirs des deux organes qui, dans la pratique, ne fonctionnent pas. Et on ne peut séparer les fonctions judiciaires et les fonctions administratives et cette division empêche une intégration harmonieuse des deux fonctions. Une réforme s'impose, comme le prévoit le titre de ce chapitre, qui doit donner plus de contrôle aux juges qui sont aux premières loges et qui voient les difficultés, les retards et la désuétude des systèmes informatiques. Ils sont les mieux placés pour trouver les solutions pour les résoudre. Cette réforme devrait s'inspirer des modèles de gestion des tribunaux en vigueur dans d'autres juridictions, notamment l'Australie et l'Irlande, où, suivant ces modèles, l'administration de la Cour relève d'abord et avant tout du juge en chef assisté d'un organisme qu'il préside. Maintenant, prochaine diapositive. Concernant le chapitre 9 sur le droit de l'immigration et des réfugiés, lors de la création de la Cour fédérale en 1971, il y avait deux divisions, la section d'appel et la section de première instance. Avant 1971, les décisions de la Cour d'appel de l'immigration étaient susceptibles d'appel sur permission directement à la Cour suprême du Canada. Donc, dès 1971, le Parlement remplace l'appel à la Cour suprême de la décision de la Commission d'appel de l'immigration par un contrôle judiciaire sur autorisation à la Cour d'appel fédérale. C'est à ce moment que se construit une jurisprudence inédite sur le droit de l'immigration par la Cour d'appel fédérale, puis par la section de première instance, notamment en droit des réfugiés. Après la signature par le Canada du protocole relatif à la Convention des Nations unies relative au statut de réfugié, le Parlement amende la loi sur l'immigration pour permettre à une personne visée par une mesure de renvoi de faire appel de cette mesure à la Commission d'appel de l'immigration pour le motif qu'elle est un réfugié au sens de la Convention. Il y a un contrôle donc judiciaire de cette décision sur autorisation à la Cour d'appel fédérale. En 1990, le Parlement modifie la loi sur les cours fédérales et énumère les offices fédéraux qui seront visés par un contrôle judiciaire directement à la section d'appel de la Cour fédérale, dont la nouvelle Commission de l'immigration et du statut de réfugié qui a remplacé la Commission d'appel de l'immigration et qui entend toutes les demandes d'asile. En 1993, le Parlement transfère à la section de première instance cette compétence pour entendre les contrôles judiciaires des décisions de la Commission de l'immigration et du statut de réfugié. La jurisprudence des cours fédérales est régulièrement suivie et appliquée dans les juridictions étrangères, notamment au Royaume-Uni, en Australie et en Nouvelle-Zélande. Des jugements importants rendus par les cours fédérales, notamment l'affaire Rajudin, Zalzali sur l'interprétation de la notion de persécution, Zalzali sur le degré de protection de l'État dans la définition de réfugiés au sens de la Convention, l'arrêt Salibian sur la définition du risque personnalisé, l'arrêt Fossu sur l'étendue de la liberté de religion, ainsi que l'arrêt Tirani du Karassu sur les conditions de reconnaissance du refuge intérieur. Dans le chapitre, j'ai aussi traité de l'application par les cours fédérales de la Charte canadienne, où j'ai constaté que les cours fédérales étaient plus réticentes à appliquer l'article 7 et à invalider des dispositions de la loi sur l'immigration parce que, par définition, la loi sur l'immigration discrimine entre les catégories d'immigrants. Par contre, lorsque la sécurité et la vie des personnes visées sont en jeu, les cours fédérales n'hésitent pas à intervenir dans les affaires individuelles sur la base du respect des principes de justice fondamentale. Plus récemment, les cours fédérales ont rendu plusieurs jugements qui ont invalidé notamment le programme des pays d'origine désignés, parce que ce programme était contraire au droit à l'égalité garanti par l'article 15 de la Charte canadienne. Et suite à ces jugements, le gouvernement fédéral a décidé d'abandonner ce programme. Les cours fédérales ont eu une très grande influence sur le développement du droit de l'immigration. Ce sont les cours fédérales qui ont souligné les lacunes dans leur jugement, les lacunes de la loi. Je vous donne deux exemples. Le premier étant l'absence de motifs élargis de protection suite à la jurisprudence des cours fédérales qu'on a adopté l'article 97 qui ajoute aux risques qui étaient déjà prévus par la définition de réfugiés au sens de la Convention, comme des risques de torture ou menaces graves à la sécurité de la personne qui ne découlaient pas d'un motif de persécution prévu à la Convention, qui était limité à la race, la religion, la nationalité, les opinions politiques et l'appartenance à un groupe social particulier. Enfin, un autre exemple d'ajout par le Parlement suite au jugement de la Cour fédérale qui soulignait le fait que la loi ne prévoyait pas un examen des risques avant renvoi pour des personnes qui sont au Canada depuis plusieurs années après le rejet de leur demande d'asile. Et malgré ces longs délais, ils seront renvoyés du Canada sans qu'un nouvel examen des risques de persécution soit fait. Donc, le Parlement a adopté les articles 112 et suivants qui prévoient un examen des risques avant renvoi, qu'on appelle erreur, dans certaines circonstances. Donc, je vais passer la parole à mon collègue Craig Forsyth. Merci.
Thanks very much. Thanks very much to all the assembled participants. Thank you very much to the judges and the organizing committee and to my colleagues. If I could have the next slide, please. So as my task on top of participating in the interviews and the overall editorial project, I append two chapters, one on the jurisdictional conundrums associated with the Federal Court of Appeal and its role in Canadian dispute settlement and more broadly in administrative law, and also a chapter on the Canadian security and intelligence community and the role of the federal court in adjudicating issues in that space. In my 6 minutes, I want to make 3 brief points on each of those topics. And so I will begin with jurisdiction. As many of you know, and indeed many of you live daily, the federal courts are statutory courts constituted ultimately under Section 101 of the Constitution Act of 1867, and specifically its language empowering Parliament to enact statutes creating courts for the better administration of the laws of Canada. So my first point is that in its original conception, federal court's jurisdiction was unnecessarily complex, and in the recent path was both predictably and also unpredictably controversial. So example number one, the Supreme Court has construed laws of Canada in Section 101 of the Constitution Act narrowly, and indeed in a manner that was largely unexpected by commentators and watchers of this issue in the late 1970s. And the effect of that line of case law and the resulting jurisdiction test that is part of deciding whether the federal courts have jurisdiction in a given dispute had the effect of dashing the federal court's utility, especially as a venue in which to litigate cases implicating not just the Crown, but also private third parties. Example number 2 of jurisdictional conundrums: the original Federal Court Act created both a predicted and foreseeable, unworkable internal division of labor between the federal court and the Federal Court of Appeal in relation to administrative law judicial review jurisdiction. And that leads me to my second key point. The administrative law jurisdictional doubts were resolved in the statutory reforms to the Act in the 1990s, as reified in the latest reforms in the early 2000s. But the Supreme Court's jurisprudence, which is grounded, of course, in constitutional interpretations, on the reach of this concept of laws of Canada in Section 101 of the Constitution Act of 1867, continues to create what I'll call unexpected curveballs, the most recent example of which was the 2016 decision of the Supreme Court in Windsor City. And that leads me to my final point on jurisdiction. In our interviews, federal court judges regularly expressed a preoccupation with the federal court's jurisdiction and often concern with how the Supreme Court of Canada had construed it. And cases like Windsor hang over the federal courts. And indeed, as Professor Green's slide suggested, Windsor ranked behind only Dunsmuir, which at that time was the most important case in relation to substantive judicial review. Windsor ranked only behind Dunsmuir as the Supreme Court cases of the judges and former judges described as having the greatest impact on the federal courts. And some interviewees certainly regard these Supreme Court cases as displacing, unpredictably, prior understandings of the federal court's role, which is a view shared also by some academic commentators. In the result, jurisdiction remains an occasional source of what I'll call interjudicial tension. Turning to the 3 points in the space on national security, in the chapter on national security. The first point is that the federal courts have become the principal courts preoccupied with Canadian national security and intelligence law, even though they never try any of the crimes found in the criminal code concerning terrorism or the sorts of crimes you find in the Security of Information Act relating to espionage. Those sorts of trials are extremely rare in Canadian practice. Instead, the federal court has developed a jurisdiction and an expertise in relation to the adjudication of other issues arising from security and intelligence law, the original form of which was the judicial control exercised by the federal court over invasive search and seizures by the Canadian Security Intelligence Service and the issuance of warrants. Now, my second point is that over time, the scope and quantity of federal court adjudication of national security and intelligence matters has grown markedly. Indeed, during our interviews, several judges pointed to national security judgments as among the court's most important. Which brings me to my last point. The federal court's expanding footprint in security and intelligence law raises 2 ongoing challenges. The first is complexity. The national security space is increasingly legalized, and that law, when combined with technological development and various procedural innovations designed to square the circle between secrecy and procedural fairness, is resource and time consumptive and has a steep learning curve. A related issue is what I'll call opacity. Because of the classified and compartmented nature of national security work, judges will be isolated and siloed in their national security role to a greater degree than even in regular judging. And so the challenge for any of the judges involved in this role is to address the often serious nature of national security proceedings with an unrelenting embrace of the rule of law. Closed proceedings bring the court into close, and in the absence of special advocates or amici, truly ex parte contact with the state and its security agencies. And without a conscientious effort to retain distance and a broader perspective, judges may find it difficult to second guess those with privileged access to classified information that may go unanswered or untested absent a fully adversarial setting. And with so much of the court's national security function occurring behind closed doors, it will be rarely evident to the public whether the court has succeeded in maintaining this perspective. In interviews conducted for this book, judges were clearly conscious of these concerns and also conscious of the generational shift in the pool of designated judges dealing with national security matters. And as it begins its next 50 years, A preoccupation for the court must be the maintenance of institutional knowledge of the sort gained, especially over the last 2 decades of national security work. And with that, I'll turn the floor over to my colleague, Peter McCormick.
Thank you. I'll be addressing my comments to the second of my 2 chapters, the one that looks at what happens if a decision of the Federal Court of Appeal goes on to the Supreme Court of Canada. I've long been intrigued by the interface between courts and by the appellate interface, by the interaction between the levels of courts as a shrinking number of cases are reviewed by increasingly large panels of judges on higher courts. But I want to look at this in terms of broader patterns and to place it in the larger framework that includes the 10 provincial and 3 territorial courts of appeal. In one sense, all 14 are variations of the same model, intermediate courts of appeal in a larger judicial framework. In other ways, of course, the Federal Court of Appeal is distinctly different, first because of its national scope, and second because of its unique jurisdiction. Now, the most obvious question about the appellate interface is how often? If many or most cases are appealed, and there are systems in the world where that happens, then on the one hand, decisions of the lower court take on a provisional character, and on the other hand, the higher court can be overwhelmed by sheer numbers. But if the appeals are infrequent or rare, then on the one hand, decisions of the lower court effectively become more final in practical terms, and on the other hand, every one of those not very common appeals becomes much more significant. So first question is how often? For the Federal Court of Appeal, the answer is about 3% of the time. Now there's 2 different elements to that in the Canadian system. About 20% of the Federal Court of Appeal's panel decisions result in an application for leave to appeal to the Supreme Court, and about 15% of those applications are granted. Both these numbers are higher than those for the provincial and territorial courts of appeal considered collectively. About 10% of their decisions result in leave applications, about 10% of which are successful, which means that only about 1% of their decisions reach the Supreme Court. That's higher for some courts like the BC Court of Appeal, lower for others like the New Brunswick Court of Appeal, but 1% is a number that reflects it pretty well. Years ago, I interviewed quite a few provincial Court of Appeal judges, and one of the questions I thought was terribly profound was, how do you feel about appeals to the Supreme Court? And I was a bit surprised then that their basic answer was they don't think about it much at all because it hardly ever happens. I think this 1% number helps explain why they reacted that way. Now, for this audience, it goes without saying, but I make the point anyway, the frequency of appeals from a court is in no way a measure of the quality of that court. The Supreme Court does not grant leave for it to appeal because they anticipate correctable error. They grant leave because the case raises an issue of significant national importance. So the Federal Court of Appeal's 3% is therefore a badge of honor that reflects its caseload and its jurisdiction. It's not some kind of badge of shame for its performance. Now, the second equally obvious question is how frequently the higher court reverses or alters the lower court judgment. The 2 questions are not unrelated. Frequent reversal invites more appeals. Infrequent reversal discourages them. The overall success rate of appeals in the Supreme Court of Canada is in the low 40% range. And a few decades ago, Burton Adkins did a major cross-national comparison and found a very similar rate for comparable courts in other countries, except for the US Supreme Court that was the exception. But okay, basically leaving that one out, 40% is about right globally. But there's a considerable variation between the various provincial courts of appeal, and the rank ordering varies over time. But the Federal Court of Appeal is consistently very close to that all-court average of just over 40%, neither higher nor lower. A further question involves dissent and separate concurrence behavior on the Supreme Court. The unique aspects of the Federal Court of Appeal's jurisdiction invites comparison on that basis as well. Most judges on the Supreme Court, in recent years, of course, all of them, are elevated from the provincial courts of appeal. This means that they are directly familiar with the types of law that are normally dealt with by those courts, so they can deal confidently with those issues. But appeals from the Federal Court of Appeal, you would think, would be drawing them outside their comfort zone, which raises the question of whether this might make them more reticent about writing separately, which takes a certain degree of confidence and familiarity. Although the numbers fluctuate over time, the overall answer is it doesn't seem to make any difference at all, and neither for dissents nor separate concurrences. It seems to for a few years, then it swings back the other. So overall, all the differences cancel out, which suggests that there's nothing structural about the way the Federal Court of Appeal is dealt with on this count. Now, a final question is whether the distinctiveness of the Federal Court of Appeal caseload affects the assignment of judgments. For just over half the last 50 years, there's been a single judge on the Supreme Court from the Federal Court of Appeal. First Ledane, then Kabuti, then Rothstein. Now, it could have been the case, of course, I'm implying it wasn't, that this person worked in splendid isolation, often writing solo minority reasons to chide his colleagues for their indifference to the unique challenges of the federal court's expertise. This would have provided a splendid springboard for a law journal article. But in fact, the numbers reveal nothing of the sort. However, the assignment of the judgment is clearly affected in a very direct way. Judgment assignment has long shown a home judge effect. It has always been true that judges are twice as likely to be assigned the judgment when the appeal is from their home province or region. But judges from the federal court, when there is one on the court, are not 2 times, but 3 times as likely to be assigned the judgment for appeals from the Federal Court of Appeal. But the critical phrase from that last sentence, of course, is when there is one. The federal court for 50 years, for 27 and a half of those years, there's been a judge elevated from the federal court, more recently the Federal Court of Appeal. At one time, I used to tell my students that there was something approaching a convention, that the Supreme Court consisted of 7 judges elevated from provincial courts of appeal, 1 from the federal court, and 1 without prior judicial experience. In the social sciences, we call this generalizing from an insufficient sample, and you're not supposed to do it. If there ever was a federal court seat on the Supreme Court, and my half the time already makes that claim very shaky, then it started with Ledane in 1984, but it may well have ended with Rothstein's retirement 30 years later in 2015. This seems to me unfortunate because, as I started off saying, the Federal Court of Appeal is distinctly different from the other 13 intermediate courts of appeal. It deals with different bodies of law calling on a different expertise. And in this respect, it is perhaps regrettable that the new procedures for appointments to the Supreme Court of Canada seem to disadvantage the elevation of judges from the Federal Court of Appeal relative to their provincial appeal court colleagues, because those provincial colleagues have provincial premiers and provincial law societies to go to bat for them. Thank you.
We have completed the remarks and we should be going to the question period. But I do want to remind you that, as you can see, and you've heard, and you've looked at the books, and you've seen the chapter, there's no way that what you've heard gives you a vision of what's in those books. So to help a bit more, there are 3 more upcoming webinars based on the books. One on immigration on October 29, on national security on November 26, and intellectual property on December 10. And I recommend them to you because, as you will see, the people who are sitting on those panels are all experts in their field. And we see the name of some of the superb contributors who help the main authors on some of the more technical subjects. So thank you very much for your brief summary of what you've so well written. We are now going to the question period. So We have a few questions. Maybe I will start with the very first one, although it may be unrelated to what we've been talking, but somebody asked why there was no land acknowledgement when we started this seminar. So I don't know if one of the Chief Justice, I have my own view of why I didn't know it, but maybe the Chief Justices have something to say about this.
If I may answer this or try to answer this as best I can, let me explain why there was no acknowledgement. As courts, we must be independent and impartial and also be seen to be as such. Fairness and even-handedness to all is paramount. We have litigation in our courts all the time between Indigenous and Métis people on the one hand, and the government on the other hand, regarding land claims and issues surrounding them. So it's important that we be careful when describing land. But let me make this absolutely clear. The federal courts have a long tradition of caring and being attentive to the rights of our Indigenous and Métis fellow citizens. This isn't just words, by words, it's also by deeds. This is seen by our carefully reasoned, detailed decisions, regardless of the results of the case. We consider ourselves in the forefront in this country in terms of advancing reconciliation. We care deeply about our Indigenous and Métis fellow citizens and the issues they place before us. That's been our way for 50 years, and it will continue to be so. I just wanted to make that clear, that being a court of law saddled with decisions that touch upon land claims, it is not necessarily our role to take positions and affirmations about existing land claims and the belonging of lands. So I thank you for that.
Thank you. And
Just add something very briefly. I understand that the position just articulated by Chief Justice Noel is common across courts across the country. But I'd also like to underscore that the federal courts have worked very, very hard to with Indigenous groups, for example, through our Aboriginal Law Liaison Committee, to make space for Indigenous custom, process, and Indigenous substantive law itself. And we've actually, in addition to talking the talk, walk the walk, as to put it slightly differently from how Chief Justice Noel just put it. So we've done a number of things that are well known in that space to make that additional space for Indigenous law and practice. So I just wanted people to be aware of that. Thank you.
maybe you can visit the site of the federal court and see that there are special guidelines for Aboriginal litigation, etc. So this was one question. I would like to go to Peter McCormick. And I know, because I know that from the book that you have analyzed more than 4,000 decisions from the Court of Appeal from 2003 to 2019. The question is, your chapter offers an analysis of the type of cases which go to appeal from the Federal Court of Appeal to the Supreme Court, and in what quantity. I would like your point of view, what stands out when you look at the federal court? That's a question that's being put. I don't know if you might be a difficult one to
Two very quick observations. I think the impression one often gets, and the comments made about the federal courts collectively, is that they are swamped with immigration and refugee law. And that is an overwhelming percentage of what they do. I was a bit surprised to discover how much that is true of the trial court and how much less true of the Federal Court of Appeal, which has a far more diverse set of cases. And then it shrinks even further when it goes on to the Supreme Court. So I think that was one of the things that surprised me, and I had two, and now it went out of my head. So that was one thing that that surprised me. Also, they considerably higher, they sort of triple the average for other courts as a percentage of total caseload that went on to the Supreme Court of Canada. Like I say, that's more an acknowledgement of the importance of issues than it is a reflection on performance. And I found that quite striking as well. So those were two of the three things I noticed, and I just forgot what the third one was. I will interrupt if it comes back to me.
Thank you. I have a question for Professor Green. You and your colleague interviewed more than 75 members of the court for this book. What is the main difference between those who sit on the bench today compared to 25 years ago? I think you need to put your...
I need to put, yes. There are two main differences. One is that the more recently appointed judges tend to be less formalistic, more flexible in how they approach their decision making. The book that was written by Ian Bushnell for the first 20 years of the court, there are a lot of pages spent analyzing the difference between the judges who were very formalistic and the judges who are more flexible. 30 years later, that's not as much of an issue. So I think that's one difference. Let's see, I think the current judges are more optimistic about the future of the court. They're very proud of the court's jurisprudence. My colleagues have mentioned how the decisions have been cited around the world. I think the judges from the earlier era were a bit concerned about some of the problems that the courts were facing and some of the criticisms of the courts. So I think there's a difference today in terms of a great deal more optimism and pride in the court.
Thank you. I have a question for Madame Valois. Vous avez parlé dans votre présentation en suggérant un modèle de gestion des tribunaux tels que ceux d'Australie ou d'Irlande. Pourquoi?
Alors, comme je l'ai mentionné pendant ma présentation, le modèle de l'Australie, de la Cour fédérale de l'Australie, était celui qui avait été justement suggéré par les juges dans leur rapport qui a précédé l'instauration, la création du service administratif des tribunaux judiciaires. En 1990, une loi a été adoptée en Australie pour prévoir que la Cour fédérale allait être s'auto-administrée. La gestion, la responsabilité de la gestion entière de la Cour a été conférée au juge en chef qui nomme un greffier pour l'aider. Ce greffier sera la personne qui sera chargée de faire rapport au Parlement des affaires de la Cour, mais un budget séparé est administré par le juge en chef de la Cour fédérale. C'est un modèle similaire en Irlande, où c'est un modèle pour toutes les cours de l'Irlande qui s'appelle Irish Courts Service. Et ce service est présidé par un juge en chef. En fait, le conseil d'administration de ce service est présidé par le juge en chef. Et ces deux modèles-là démontrent qu'on peut facilement concilier une gestion de l'administration des cours par le juge en chef et la transparence et la responsabilité de l'utilisation des fonds publics par l'entremise d'une personne, d'un greffier, qui relève du juge en chef, mais qui va être chargé de faire rapport au Parlement et de présenter ce rapport lui-même devant un comité parlementaire.
Merci. Il est 5h30, mais j'ai une question. Et je l'avais gardée pour la fin. Elle est pour the question is for Craig Forsese. It's a tough one. So I kept it for the last. before we all go on a weekend. I'm sorry. You have been speaking about the trial and tribulation of the court's jurisdiction. You say the full of implication of Windsor are still uncertain. What would it take to clarify the situation?
Well,
Not to put you on the spot.
Yeah, I know. It was a really good case. No, so here's the issue, right? So how do you reconcile Windsor City with, say, the approach taken in Liberty Net? And so, to what extent is the trial and tribulation of the federal court jurisdiction a question of narrow doctrinal interpretations of the law, whether it's the Federal Courts Act or the Section 101 of the Constitution Act of 1867? And to what extent does it reflect the Supreme Court of the era's view on what inherent jurisdiction means? And my view is that it's a wax and a wane of the concept of inherent jurisdiction. So you take Liberty Net, and in Liberty Net, the Supreme Court said that inherent jurisdiction wasn't supposed to be a system of creating a hierarchy between the federal court and the provincial superior courts, but rather was simply a backstop to ensure that there's some court somewhere that's always capable of resolving a dispute. That was Liberty Net, but in Windsor, we seem to have reverted back to a more, shall we say, a doctrinal effort to tease apart the significance of the Constitution Act of 1867, which I think masks, frankly, just a narrower concept of inherent jurisdiction that gives primacy to the provincial superior courts. And to add, and I'm guilty, Justice Gauthier, of having worked on this book, like every biographer, I become more sympathetic to my subject, right? So not to be a partisan on the matter, but to add injury to insult in Windsor City, there's the obiter statement suggesting that the federal court is not competent to issue constitutional findings erga omnes, that is, that apply generally, but simply apply as between the parties, without any explanation as to why that sprung from the ether. And so one reads this and one wonders whether the fate of the federal court's jurisdiction, at least in these areas, just depends on the composition of the Supreme Court at any given time, especially since these are deeply split cases that are usually 5-4. So your question is, what will it take? Short of a constitutional amendment of Section 101, it's probably just a question of the evolution of the thinking of the Supreme Court. And I have to say, per Peter's comments about whether there's a federal court judge sitting on the Supreme Court, maybe that matters.
Thank you very much. And I want to reiterate, although they seem to be more sympathetic to their subject, they had total freedom in respect of their views and whatever they wrote. So I want this to be extremely clear. So thank you so very much. It's as I say, it's very difficult to do justice to your work through a session like this. But I hope that you out there, there may be more questions, but I think you've been very generous and nice to be with us on a Friday late afternoon. So I want to let you go. And I thank you all for participating in this. My style is I would have liked to see you in the eyes so that we could communicate our energy. But as I said at the beginning, we have to do what we have to do. And what's important is that we've been together to celebrate the launching of, again, these fabulous books. Okay, so the only thing I can say is bonne lecture, good reading. Have a good weekend.
Au revoir. Thank you.
Au revoir.
Au revoir.